I don't understand why you are still pushing your luck. You were supposed to register immediately upon doing the 3 days as a condition. When did she do the 3 days, please?
September 20th is when she went in, and that Monday, I think, it reinstated her, Judge.
Yes, Judge, it was September 20th.
She did, she was released on when, the 21st?
The 23rd. 23rd is when she was released.
Released the 23rd. She was supposed to register immediately.
Whoa, right here's a huge deal. When a judge orders you to register for a program immediately, that means no excuses, no delays. In legal terms, every day you wait can look like defiance of a court order. And 4 weeks? That's practically begging the court to lose patience.
Immediately starting the IOP. And what day did she register?
Yesterday.
Says her probation officer told her she had a month.
I told you here what you were supposed to do. I'm tired of playing this game, Andrea.
At least she's registered.
It's like, you know, when this is what happens when you're too nice. It's over and over. People take advantage of you like crazy. It took 1, 2, 3, 4 weeks for her to sign up for IOP, Andrea. 4 weeks.
Can you, since she's already registered,
No, I mean, I'm done with this. I'm just, what?
let her see if she goes, if she attends? I don't have there's not much that I can say. I don't have much to stand on. But
Doesn't take us seriously.
I'm hoping that you will allow, since she's already registered, you'll allow her,
Let's do this. Let's do this.
because she has an ankle monitor on. That's on. It's
I'm
on.
gonna send her for a drug test right now. I want to see what if anything that she's going to test positive for. And then right now I want to send her for a test. And then I guess we'll talk when she comes back. Because first things first, I want to know if she's clean. If she's not clean, it's over. That's it. But if she's clean, then we'll talk about how we go further.
Did I send her back here? How long, so I know how to manage everything else that I
I have
have.
your cell phone, right?
Yes,
I'll text you when she comes back
okay.
and I don't know. Just take a seat for a minute.
Thank you, Judge.
Thanks, Andrew.
Go to Ms. Ramirez.
Absolutely.
The state position is that we follow the recommendation of the
Yes.
probation department. Either feels A, she's reached a point where they can no longer help her and she needs a higher level of care than the probation department can give her. Or B, if the probation department feels that they can still treat her, we follow the recommendation of the probation department. We being Texas.
And there requested a 6-month extension, but her class been on 7 months.
But Judge, if she registered for the classes, there will be completed in 6 months.
I'm not doing a 6-month reset for her to do one class a
We
week.
can bring her to court. We can bring her to court for status updates. I'm 100% on board with that. I think that that's actually a very good idea. But what I'm saying is that the probation department feels that she could be helped with the IOP and SOP. That's my understanding. Please correct me if I'm saying something wrong. My understanding is that probation department feels that they could help her with the IOP SOP. I think that to her defense, nobody told her she needs to register, at least as far as I'm aware, 2 to 3 times a week. So
I
if
told her last time we were here.
now when we approached, because I was with her,
Yes,
Judge.
I told
I
her.
was with her and I don't remember you saying that.
I told her what you need to have done, and then this is what you register for. When you come back, this is what we're gonna end up doing. Regardless, look, regardless.
What I'm saying is, since the probation department feels that they can help her, if she can register to one of the 3, and I'm gonna bring her up here if you decide to allow her to continue, I'm gonna bring her up here and we all talk, so everybody's on the same page. If she does it within like a week, not a month like we did last time.
I'm not ever,
This is a classic courtroom cat and mouse. The judge is basically saying, I've seen this game before. It's like testing how far you can push before consequences hit. What do you think? Is she being too lenient here, or is this the right amount of patience?
going to reset her for over 2 weeks at a time
And that's
because I
fine.
can't trust anything to happen.
And that's fine.
And Mr. Lindsay, unfortunately, the way it works is that it's unfortunately, like a little child. They push and they push and they push. And it's truly, it's childish because they push and they push to see how much they can get away with. And as evidenced here, you sign up the day before court.
This is all predicated on if the court does not rescind its order for supervision.
What I'm going to do now is I'm going to reset her for 1 week. She has 1 week to sign up for the 3-time-a-week course. She needs to come back, show us that she's done that. And then after that, I'm going to set her off 2 weeks. Every single 2
Can I bring her up
weeks.
here? So
Sure.
I want her to be part of the conversation, so if she comes back and she doesn't do, so nobody can, so there's no possibility of saying,
I'm so over this, it's just ridiculous. Come up, Ms. Ramirez. So I will indefinitely set this case off 2 weeks at a time to make sure that it gets done. Because I can't do 4-week resets anymore, unfortunately. So we are now going to have to micromanage just I don't think that this is right. And I don't think that this is fair because it really spits in the face of every single person who does a good job with this program. And what you're doing now is not what this program is designed to do. And it really violates the spirit because this is a program that's supposed to teach you right and wrong, teach you how to act in the free world. And you've done everything against that. I mean, for you to sign up for the class 1 day before court, it's just, it hurts. And it's shameful. Because when I told you, last time you were here, I told you that I wanted you to sign up immediately after you were done. And you sat there and you waited. Not 1 week, not 2 weeks, not 3 weeks, 4 weeks.
Oh, person's calling back.
So now you've shown me that I can't do long resets on your case. So if you fail one more time, if you ever fail to attend a meeting, if you ever fail to whatever you need to do, you will be out of this program. I will not do this again, and I will immediately set your case for trial. You have 1 week to sign up for the class that's 3 times a week. And thereafter, you will get 2-week resets every single time to show me that you have attended this class 3 times a week. If you fail to go one of those times in a week, because it's the class is designed for you to go 3 times a week, every week. And if you fail to do that, that's it. Do you understand?
Yes, sir.
Judge, just to make sure we're all on the same page. Judge is asking you to go back to that list that you have and find a place that offers the program 3 times, IOP 3 times a week. What are the requirements? Is SOP once a week or,
But she
okay,
has to complete IOP first.
right. So you have to go back to the list, find a place to register for IOP that does it, that meets 3 times a week. You do IOP, and once you're done with IOP, you find SOP that meets once a week. And you have to
90
have,
days. Okay.
right, and you have to be registered in the IOP that meets 3 times a week by next court setting, which will be in about a week.
Not about exactly a week.
Okay, do I have it
Next
correct?
Wednesday.
Do I have it correct, Judge? Right, okay, so do you understand that?
Yes.
There's not gonna be another chance. Okay.
State has nothing further, Judge, for the court.
See you in a week.
Thank you, Judge.
Morning, Mr. Dunham. How's jail?
Terrible.
Great. That makes me happy. Because you got to understand, the worse of an experience you have, the higher likelihood when you do eventually get out, you'll think, if I do this, what's going to happen? If I say this, what's going to happen? Because that is the most important thing. You got to understand, we value public safety. It's really, really important to us. So you're here now because it looks like you picked up a case out of state and you want me to set you a bond. Is this right?
Yes, sir.
You need to understand that my only concern are two things. Number one, are you a danger to my public? And number two, if we set you a bond, are you going to go back to the jurisdiction that you wanted from?
Yes, sir.
Those are the two things that I'm concerned about. So, what's he wanted for out of state?
He's wanted out of South Carolina for robbery.
Robbery?
Yes, Judge. State would be opposed to a bond. He's currently has an open case of engaging in organized criminal activity. He's also on deferred for a third-degree felony theft, which he has not yet made the bond collectively of $50,000. He's also had a prior evading with a motor vehicle, misdemeanor evading motor vehicle, criminal mischief, and a theft. And it looks like based on the dates of each charge is that they're slowly escalating. It started with catalytic converters where he's using electric saws to steal them, but in the last evading is that he was also driving a stolen vehicle, and obviously now he's using weaponry or threats. And so based on the fact that from 2022 to now that he has been charged at least 6 times, 3 of which are felonies, and the fact that he has 2 open cases that he has not yet made bond on, is that he's a definition of a flight risk and safety risk. So I would be opposed to it.
Judge, Mr. Denham is requesting a bond because he has finals on Monday.
Finals?
Is a sophomore, major in nursing at Southern University in Baton Rouge.
Are you really in school? Really? But you're in Houston. You have finals on Monday?
No, I came right with this.
Keep it down, please. I'm going to read something to you real quick, okay? And this is from what I'm reading now. This is from the magistrate. Motion for bond conditions, Harris County, none. Defendant has a hold. 10/16/24. Officers conduct an undercover sting crime suppression operation to catch suspects who are engaged in organized criminal activity, bank juggings. Officers use bait victims, undercover officers posing as bank customers, and bait vehicles. 3 suspect co-defendants, DeLeon Dunham, Messiah DeLeon Dunham, and Treventi DeMarcus Hilliard attempt a bank jugging on 1 bait car, but are unable to break the window. Shortly thereafter, they conduct a bank jugging on a 2nd bait car and this time break the window. Bus signal given, and the officers execute a vehicle containment technique and a felony stop and apprehension. All 3 suspects, defendant in possession of criminal instruments. You're on probation for a 3rd-degree felony. You have an open robbery out of a different state. Let me ask you again. Do you really want me to set you a bond?
I was just asking if it was possible.
No. You got to understand, at some point, we really, really value our public safety. Mr. Dunham, we are going to do everything in our power to protect it. And if I give you a bond, you may very well pick up did you say 6? How many charges?
Total in the course of the last 2.5 some odd years.
6?
6.
Sometimes we have to protect people from themselves because of their own cost. So, Mr. Dunham, I'm sorry, but I really think that you are a complete danger to our public, so I can't do it.
All right.
I'm sorry. But
The local is likely going to get reset for Tuesday, then reset again. He's set for preliminary appearance upstairs, so it's just an arraignment, but it's likely going to get kicked out again for discovery. And so I'm just letting.
here's the deal, though. You need to understand that you have not made bond on your felony case. Okay, well, here's the deal. The problem is that while you have not made bond, your case here, the fugitive case, remains in a holding pattern. So the time that South Carolina would normally need to come get you is told until you make bond on that felony case. The other thing is this, is that you're also on, Dave, where was he on felony probation from?
On deferred adjudication out of the 338 District Court for a third-degree felony theft.
I wonder why I can't even see that. I don't, have they issued a motion to revoke on that one as well?
No, they set. Well, for some reason, it says to hold on JWeb, but it doesn't show it on, yeah, no, hold on.
It's just from a couple of days ago. I'm assuming they're just following the MAJ today.
On the,
Is that what you see, Dave?
Oh, you're right. They haven't filed the MAJ yet, but I can't see the processing queue in the 338. So
So-
if file it, it'll be this weekend.
at some point, they're also probably going to issue another warrant for your arrest because of all these cases now, because you're on probation. So at that point, you'll also probably have to set a bond on that one, or they may not set a bond. I don't know.
Right.
How old are you?
20.
You're 20?
All right.
Going the wrong way, Mr. Dunham. You're really, really begging for a lengthy prison sentence, dude. That's it. Okay.
Thank you, Judge.
Thanks.
Thanks, Judge.
Judge, I would like to say that the VBR is kind of, it conflicts with itself. It says there's a tamper, then it says there's alcohol detected, but alcohol cannot be confirmed because of the way it was tampered with. So I don't know if we have further information to.
We never do. We never do. And the problem is that what happens is people try to put stuff. What is the one thing I asked you? I'm sorry, I ordered you not to do.
Not to drink alcohol, and I haven't. I'm 51 days sober today. And
I
I
have.
live in a sober living facility, so I get breathalyzed and drug tested at least 3 to 4 times a week. Anytime that I leave and I come back. I went to an inpatient program and I completed that. I have my certificate right here.
Show me that you have a breath test on 10/26 at 9 in the morning, because if what you're telling me is true, you should have a breath test at around that time, and let's see.
Yeah, I would have to get with the coordinators of the staff at the place that I live in. I'm sure they have it all logged.
You're supposed to have that here today, though. Today is the day that's set for your bond violation hearing.
Well, Judge, we didn't go over all that because I was hoping to get more detailed info. It sounds like there's a tamper, but they're not confirming alcohol. They're not confirming alcohol.
Because of the tamper. What we have normally is someone does something to the device to the integrity of the device to bypass alcohol detection. They could put a sock in between, they could put a piece of paper in between, they could kind of move it so the skin is not touching the device. There could be a whole myriad of things of how the actual tamper takes place. All we know is that we have a tamper and we have a we have alcohol detected. We can't confirm because of the tamper. The nature of the tamper prevents confirmation of alcohol.
Judge, sometimes these devices, they're not perfect, Judge. They can't ever tell me what happened.
So if there's ever a problem with the device, it is your responsibility to go to the place and get it fixed.
Yes, sir, and I did. Whenever I went to Sentinel, I asked the guy who put it on me and was downloading my data, I asked him to tighten it because I felt as if it was too loose. And he did tighten it, and he said he wrote down on his notes that he tightened it for me. I've been sober for 51 days, and
How do I know that?
I have my certificate that I went to an inpatient program and I'm living currently in a sober facility. And I'm doing that for myself because I do have an alcohol problem. And I'm 51 days sober as of today.
If you're telling me that you have all that information, that they test you frequently, then you should be able to have testing at that time. And if you can show me that you have a breath test at that time that shows that you're not have alcohol on board, then I'll throw the piece of paper away.
And we do this, Judge, would you allow us to get time to get those documents for you? We weren't prepared to present that to you today. I was looking to get more info on the actual report.
It's supposed to happen today. You guys are supposed to come in between the time we let you know about the violation, to do your diligence, to figure out what the violation is, how it occurred, and how to remedy that.
Judge, that diligence isn't on us, Judge. They're the ones alleging this. They need to
No,
provide.
they're not alleging anything. I am, because you have alleged violations here. It is your duty to show us why
We could bring these people that are alleging this tamper, we could bring them and have them testify regarding what they know and what they do not know. Instead of just assuming that they are correct, we could have a hearing.
No one's assuming anything. I'm telling you, if you have something that contradicts this, show it. That's what I'm telling you.
I also did my due diligence of making them tighten it. I told them to tighten it myself.
I understand
And he
that,
did say he wrote a note about that. Because I
I
was
still
afraid
have-
that this would happen.
Mr. Barahona, I still have alcohol detected, regardless of whether it's tightened or not. The tightening is not the issue. The issue is that there's a tamper and that we have alcohol detected.
I have not consumed any alcohol.
So show me. I'm telling you how to do it. Reach out to them now, see what you can get. See what evidence is out there to show me, I'll put you guys to the side, reach out to them, see what they have. If you're telling me that they've tested you as frequently as they are, they should have something.
Let me talk to my client, see how quickly we could get that info.
No rush. No rush. Take your time, see what you can find. Okay, Ricardo,
Judge, we're approaching on Mr. Ramon Barahona.
do you need until Monday?
No, because here's what's going on. So I was kind of unsure about what he was talking about. And after talking to him, we're not going to have a breath result for him because they haven't been testing him, is what it sounds like. And so we got two options, Judge. The way I see it is two options. One, you could revoke them, you could say, well, let me talk about what the specific is on the revocation. Alcohol was detected during tamper. However, alcohol cannot be confirmed as consumption because of nature of tamper. So I would argue, I'm not conceding that something happened. I'm conceding there might be a tamper. I'm not.
Come up, Mr. Barahona.
If you're going to revoke him, I would ask for a full-blown hearing. If this is one of those situations where he's just admonished and, hey, this is your one shot, then he understands that. I don't know how you want to proceed with this, Judge. I'm not conceding that he drank alcohol. He's been in this location, in this Center Core location since September 17th. He did inpatient. October 18th, he graduated. Then he moved over to Center Core's sober living facility on October 18th. He's been in there since then. We have proof of that. He's been attending 6 meetings per week, 1 counseling session per week, 1 group counseling session per week, 3 AA meetings. He's there. He's doing something. I would ask that we just admonish them.
Machines don't test positive for shites and giggles, man. They don't. There has to be something there to make it test positive.
Here's the tension point. The device says there was tampering and alcohol detection, but the defendant swears he's sober. In cases like this, the court doesn't need absolute proof of drinking. The violation alone can be enough to crack down hard. If you were the judge, would you believe him?
Well, Judge, on that aspect.
It doesn't spontaneously test positive for alcohol.
Well,
For you to say that it does, it's just disingenuous and not true. There has to be something to set the machine off. It doesn't spontaneously test positive.
I have not consumed alcohol for 51 days as of today.
The machine is telling me differently, Mr. Barahona. You know how many people tell me the same thing with the exact same facts that you have? You know how many times I hear it a day?
I would assume a lot.
If I had one strand of hair every time I heard it, oof, I would look good.
Judge, I did talk to him. This wouldn't be much of a solution since this is from 1026, but we could test him today. I don't know how long something stays in the system, if that's the allegation, but he's willing to test today.
That's going to be no bearing on me. I
Right.
mean, this is 2 weeks ago, you know?
I get it.
I'm just now, unfortunately, they just give us the results now, but
And regarding the actual, I've gotten reports before that says what this device is reading. There are reports out there that they can provide.
if they don't tamper, then yes, you will get a true and accurate reading. And that's what the problem is that there is something that was tampered with, and Mr. Barahona knows. He's the only one that knows what happened on that date. We don't, because we weren't there. We don't know what happened. So I'm sorry, Mr. Barahona, but I told you one thing, and I told you one thing only, you know?
I would like to state the fact one more time that I did tell the people at Sentinel to tighten it because I didn't want something like this to happen. I don't
This
think
is
it's,
not a matter of tightening. It's a matter of alcohol detection. If a device is loose, it's not going to test positive for alcohol. You understand that?
I
Just,
understand what you're,
there has to be an intervening event that has alcohol in it for it to test positive. And there's something seriously afoot because the device is telling us that someone is messing with the machine. If we not had the messing with the machine, then we would know whether there was true alcohol consumption or not. But here we have a positive and that you're messing with the machine. Okay, goes with you.